Welcome to Frank Bruno Law. I am Frank Bruno. Today is the fourth video in the 6 steps to the probate process. I have now decided to change this to the 7 steps. We've gone through, I started the series with the intention of preparing a giveaway called the 6 steps to the probate process. And then in real time, every day, I've been working a little bit on it, and I decided to do 7 steps. The 6th step I've been speaking about is the filing of the petition, the actual physical petition, whether that be electronically or in person. And if it's truly uncontested, if all of the heirs, beneficiaries, people in the will consent to probate, it's uncontested, it gets filed without a court date. If the executor or the distribution is challenged in any way, it becomes a contested matter and you have to make an application to the court for a citation. Now, let's say that we get through that, and maybe there's a little bit of a challenge, but the person doesn't. So a challenge is a funny word in the sense of a person could choose not to sign a consent, but then not show up in court. That's less contested, but it would have delayed the process and caused a court date. Say we get past the citation issue in the surrogate's court. What is the next step? Well, and again, step 6 was mentally we're thinking about that. Do we know that there's going to be a challenge? If we don't have consents, then we know we have to ultimately ask the court for a citation. Now, step 7 is to file the petition along with the items from step 1 and 2, right? So what does that mean? We file the petition, our affidavit of comparison, our affidavit of attesting witnesses, our waivers to probate, consent to the matter, any other affidavits that we have determined would be necessary that go along with your petition, with the original last will and testament, the original paid funeral bill, and the original certified death certificate. All of those items are filed with the court along with a filing fee. As I mentioned, the filing fee is on a sliding scale. And once it's filed in the court, then we can wait for the surrogate. That's the judge that's in the probate court in New York. Our probate court is called the surrogate's court. The surrogate is the judge in that court, will issue letters testamentary. Okay? So that's the probate process in a nutshell. Even as I try to make it simple, it's almost like a choose your own ending book, because it depends along the way what happens. It's like when you sit down at a dinner table and you have a fork, a knife, and a spoon. Well, those items, those utensils are there for whatever food is served. So if you have soup, you'd grab the spoon. If you have a meat, you might grab the fork and the knife. I'm going to work out that analogy for future use. If you would like to speak about your probate matter, if you don't have a will, that would be an administration. Please give me a call about that as well. I can work you through the process. I can tell you what's expected and how to get from beginning to end in the smoothest possible way, even while these are very difficult and serious circumstances. Right? We're dealing with the passing of a loved one, and I joke around a little bit about the process in the words I say, and give some levity. but it's always a serious matter, and I always treat the matter with the utmost respect and reverence. If you need to speak with me, frankbrunolaw.com. Thank you.